Thank you. Mr. Penwell.
Thank you. I think it's always a bit of a concern when you have the fox guarding the hen house, and I think that's the concern that we ought to have with the Supreme Court in charge of these things. You know, there's not that much accountability there. I don't think there's good perspective. I don't think there's good objectivity. I think it would be better if the legislature did it, because these are elected officials who have much more accountability and would be much better able to respond to what the people want in terms of that particular decision. So I would say that it would be much better for the legislature to handle that.
Thank you. Ms. Hennessy.
Could you repeat the question one more time?
Right now, the Supreme Court makes their own rules of conduct and administration. Should the legislature adopt a statutory code of judicial ethics? Do you think there should be changes in the way the Supreme Court makes rules?
It's a very difficult question. I work in the courtroom every day and assist in writing orders every single day, listening to jury trials and court trials. And in the district court, trying to follow the precedent of the Court of Appeals and the Supreme Court, it's very difficult when the Supreme Court turns around and does something and doesn't follow what their rules are themselves. It makes it very hard for the district court judges to figure out what they need to do on a regular basis when they're trying to follow the precedent that's made. I'm not sure that going to the legislature is the proper avenue. I think something needs to be done, but at this point, I'm not sure what that would be.
Thank you. And then I have, somehow I messed up. I have just one name. Was there anybody else I missed? You're the only one. Okay, because Mr. Marker, I called you accidentally. You know what? I'm going to give Mr. Marker a chance again, too, because he didn't get any warning about his question. So the very last question I was actually touched on already, but not totally answered. And the last question for Ms. McPherson and Mr. Marker is going to be, it is said that justice delayed is justice denied. Do you have ideas for ways to improve judicial efficiency to reduce delays? This is different from the question previously, which had to do with the economics, though they are certainly related. Ms. McPherson.
Thank you. As Mr. Stebbins mentioned, I think one vehicle is early case management, because if the cases can be resolved quickly up front without being delayed, that is very beneficial. I co-chair the Early Neutral Evaluation Committee in Anoka County, and we have found that it has significantly reduced the conflict in family law cases. So I think that particular model is a good one. In addition, one of the other pilot projects that we're doing in Anoka County right now, I volunteer with Mediation Services, and we're trying to put in a mediation component in the conciliation court to try and get resolution quickly to conciliation court matters as well. I think we need to look at vehicles like that, but with the full realization that there are times when litigants need to get before the court quickly and have their dispute heard and decided.
Thank you. Mr. Marker.
Thank you. I certainly agree with the statement that justice delayed is justice denied. I think that one quality that a district court judge should have is that he or she should be an excellent manager of resources. These courts have huge caseloads in addition to the attorneys and parties that appear before them. And they simply have to have the ability to get through court calendars, because when they don't, it backs up and it affects everybody else, and it affects the entire system of justice. I manage a division at the Attorney General's office right now that handles 5,000 case filings per year. There's 12 of us that handle that caseload throughout the state. And I think it's critical, again, that district court judges have the ability to manage a very large caseload, especially in these tight resource times.
Thank you very much. We're now going to enter our 5th round of questioning, and the category title is quotes. I'm going to give a quote and ask you to respond. And we're going to do the same thing where I'm going to call 3 names. I will try to do it correctly this time without making mistakes. The first 3 I'm going to call are Mr. Stebbins, Ms. Hawley, and Mr. Steigoff. And the first quote is, "It has been said that power corrupts and absolute power corrupts absolutely. Does this saying apply to the judicial branch? And if so, what can be done about this?" Mr. Stebbins.
I thought maybe all I had to answer was Henry Kissinger, but number one, courts don't have absolute power until you get maybe to the U.S. Supreme Court, but none of us are running for that right now. They don't have absolute power. There are checks in the system. The biggest check, of course, is the electorate. The checks by the appellate courts come into play. So there is no such thing as absolute power at the district court level. As far as power goes and power's ability to corrupt a district court judge's principles and judgment, frankly, I think we've all seen it happen with various people, and it's kind of a personality related issue. A judge has to have the temperament, has to have the horse sense to look at things from the everyday perspective that the parties coming in see things. And by doing that, you maintain your compassion and eliminate the corruption that could result.
Thank you. Ms. Hawley.
I agree wholeheartedly with Mr. Stebbins. I think if we didn't have our system of checks and balances, then we would absolutely be in a position where we saw a lot of absolute power leading to corruption in the judicial system. But we do have the checks and balances. And we do see people who get carried away with their power. I think it's sometimes hard not to, and that's why it comes back down to you have to be a good judge, you have to have a large quantity of humility and recognize that you're a public servant and there to serve the people, not there to stamp your name on anything or to make a name for yourself. It's all about helping people through situations that they can't get out of themselves.
Thank you very much. Mr. Steigoff.
I believe our Constitution was enacted with that realization in mind. The Founding Fathers coming over saw that, saw what it was like to have people follow the rules, follow the law, only to have the king or his cronies preempt, and they knew they couldn't have justice. That's why the judiciary is separate. As far as the saying, you could talk about that in a think tank for days, weeks. We have a system that's designed to prevent that. I think it's important that our system function. To have that system function requires an independent judiciary, so we're not being told what to do in your case. Protect your own rights. Make a good choice when you vote for judge.
Thank you. The next question I will be directing to Ms. Smits, Mr. Jude, and Ms. Arnold. At her recent confirmation hearings, Justice Elena Kagan said, "What my political views or my constitutional views are just don't matter." Do you agree? Ms. Smits.
Could you please repeat the first part of that question?
This is a quote from the confirmation hearings from Justice Elena Kagan, and she said, "What my political views or my constitutional views are just doesn't matter." Do you agree?
If this is in relation to electing a judge to the bench, I believe your political views shouldn't matter. With all apologies to Mr. Wurstel. I think an impartial judiciary is very, very important. And although, having said that, your constitutional views are important because judges are sworn to uphold the Constitution and the laws in the state of Minnesota.
Thank you. Mr. Jude.